Well, the Supreme Court did it again. Specifically, they have refused to make a decision on whether or not they're going to grant cert or not to the cases of Snope as well as Ocean State Tactical. But they did issue a couple of decisions effectively denying cert in a couple of big cases with dissenting opinions from Justice Thomas, Gorsuch, and Alito. What does all this mean? How to analyze what's going to happen with our rights under the Second Amendment with respect to assault weapon ban cases out of Maryland and the magazine ban case out of Rhode Island? Let's break it down and make you the smartest person in the room as to what might be going on and the tea leaves to read when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxer Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so you all know the story by now, which is that the U.S. Supreme Court has still not decided whether or not they're going to take the case of Snope versus Brown, which is the AR-15 semi-automatic rifle ban case out of Maryland, or whether they're going to touch fingers with and make a decision to grant cert or not anytime soon in the Ocean State Tactical case, which is the magazine ban case out of the state of Rhode Island. These are the hot ticket items. We all know what we're cheering for. We're cheering for them to grant cert in Snope and, frankly, to take Ocean State Tactical and put that one on a shelf because I don't think they're going to take both cases, and I don't necessarily think we want them to take both cases, because if they take both cases, it increases the odds of some justice like Justice Roberts or Justice Kavanaugh splitting the baby and ruling in our favor with an AR-15 case of Snope and ruling against us in the magazine case of Ocean State Tactical, even though that would clearly be wrong. But to minimize the chances of splitting the baby, we do not want, in my opinion, for the Supreme Court to grant cert in both of those cases. We just want them to grant cert in Snope and to put, again, the magazine cases, such as Duncan and Ocean State Tactical, on the shelf pending the outcome of Snope. That's kind of how I see it in the real world, not my fantasy utopia that I'd like to live in, but I don't live in a fantasy utopian land, so I have to kind of give it to you as I see it in the modern world where we really are in the world today. Now, with that said, let's talk about what the Supreme Court did, in fact, do and what we might be able to glean from that. I'm hesitant to kind of, I don't get up at like 4 in the morning to cover some of the stuff because I don't think it's necessary. But I do want to give you sort of the realities on the ground of some of the Supreme Court litigation, some of the tea leaves that you can read, some things that may be going on and how to analyze this. Because I know a lot of you turn to this channel specifically to learn this information so you can use it on your channels, in your op-eds, just to understand how the Supreme Court functions, how the bar of the Supreme Court functions, and so on. So I do have to give you some of this geeky information, although sometimes I'm hesitant to do so because I don't necessarily know if you need all this stuff, but I know a lot of you like it, so I'm going to give it to you with that in mind. So to begin with, obviously, we know that we're now on a very big number of relists. And what does that mean? That the U.S. Supreme Court started conferencing the Snope case and the Ocean State Tactical case sometime in kind of late December, early January, and they keep relisting it, which means they keep pushing it off to the next conference and the next conference and the next conference. And now we're on something like the order of magnitude of like 14 different conferences that these cases have been conferenced. And as you know, what it means for the Supreme Court to conference a case is that they all sit around a room, meaning the Supreme Court justices, of which there are 9 of them. They sit in a room together with no one else in the room, and they vote as to whether or not to hear a case. It takes 4 justices to grant cert to hear a case, but if you are interested in a topic and you're not sure you have 5 votes to rule in your favor on the merits of the case, you might vote to deny cert, even if you would like the court to hear the case and rule in favor of your viewpoint. But if you're not sure you have the 5 votes in favor of your viewpoint and you don't feel like you've locked in the outcome you want and or the way the opinion should be written, you might yourself basically deep 6 the cert grant by voting against it yourself. Even though you might want cert to be granted, you might vote against it if you're not certain of what would be the final outcome. So with that said, where are we with Snope and Ocean State Tactical, and how does this compare with other things? Well, we know where we are right now. We're somewhere in not record-setting, but getting close to a record set for the number of relists, which means the number of conferences where the court has gotten together, sat in a room, and voted whether or not to hear these cases, and they keep reconsidering this and shoving this off to the next week. Now, there's a lot of speculation as to what might this mean. If I were giving you the answer on a bar exam, the most obvious answer on a bar exam would be, well, what's happening here is that the Supreme Court is likely going to deny cert in Snope, deny cert in Ocean State Tactical, and some one or more justices are going to write a dissent from the denial of cert saying how this is terrible for the Second Amendment, and that is the most likely outcome. And statistically speaking, even today, that remains the most likely outcome. I hate to say that, but that is still likely true as a matter of statistics. With that said, the fact that we have so many relists here, meaning they keep conferencing and conferencing and conferencing these cases, and again, we're somewhere in the order of magnitude like 14 or 15 conferences or relists of these conferences, we're starting to get into what I call the Dobbs territory. And what is the Dobbs territory? The Dobbs, of course, is the decision, in addition to being leaked to the press ahead of time, the opinion, the Dobbs decision is obviously the decision where the U.S. Supreme Court said that you have no right to an abortion, and the decision from the 1970s called Roe v. Wade was wrongly decided. Now, the reason why I mentioned the Dobbs decision is that was a case where the relists were something like, 20 times before they finally granted cert and agreed to hear the case. They kept delaying that case for several reasons, according to reporting. They were delaying the case. One is they wanted to push it off to a different term, and number two, they were trying to negotiate internally how the case might get resolved in terms of which side would win the case, and just as importantly, how would the side win? Would Roe v. Wade be overturned, or would that law be upheld and Roe v. Wade would not be officially overturned? Obviously, in Dobbs, it was overturned. 5 justices overturned Roe v. Wade. Chief Justice John Roberts said he would not have overturned Roe v. Wade, but he would have ruled in favor of the majority. And of course, the liberals would have opposed all of the above, knocking out any and all abortion restrictions in America. So with that said, where are we again with Snope and Ocean State Tactical? We are still likely in a situation where there's probably going to deny cert with some sort of dissent. But the fact that the number of relists has grown so large, we might be in that Dobbs territory where the court is still going to grant cert and hear it. And I don't think that's an impossibility because of what just occurred just now with the 2 cases that the Supreme Court denied cert to yesterday. But there were dissents. Specifically, there is the Apache Stronghold case out of the Ninth Circuit Court of Appeals, which I talked about before. That is actually an older case than Snope or Ocean State Tactical. Apache Stronghold deals with the First Amendment's religious liberties clauses. And in that case, they started having conferences in Apache Stronghold even before they started having conferences in Snope and Ocean State Tactical. And nevertheless, even though it's been granted, it's been relisted so many times, finally the Supreme Court on Monday or on Tuesday came out and denied cert in the case over a dissent by Justice Gorsuch. And then relatedly, another case, and you're going to see why this is important in a second. In another case called LM, there was a First Amendment case dealing with student rights to free speech in public schools out of the U.S. Court of Appeals for the First Circuit, which is out of Boston, Massachusetts. And the Supreme Court just denied cert in LM over dissents from Justice Thomas and Justice Alito. Now, what's interesting is that LM, listen carefully, folks, this is the key. The LM case where the Supreme Court just denied cert has been around for a less or shorter period of time than either Snope or Ocean State Tactical. In contrast, Apache Stronghold has been around, binging back and forth as to whether or not cert has been would be granted in the Supreme Court longer than Ocean State Tactical and Snope. Hear what I just said? Apache Stronghold had been relisted more times than either Snope or Ocean State. But the LM First Amendment case out of Boston had been relisted fewer times than either Snope or Ocean State Tactical. So what does this tell us? What can we read from these tea leaves? It tells us this is a bit of good news, a bit of hope. Why? Because it shows that the Supreme Court is not just going in order of cases as they come in and deciding them. Because if they were just doing that, Apache Stronghold would have been decided, and then Snope and Ocean State Tactical would have been decided, because LM, which was just decided with a denial of cert and a dissent, is a younger case, meaning fewer relists than either Snope or Ocean State Tactical. So the Supreme Court is specifically doing something special with Snope and Ocean State Tactical. They're not going in order, because if they're going in order, they would have done Apache Stronghold, and then Snope, and then Ocean State Tactical, and then LM, but they didn't do that. They did today Apache Stronghold and LM. So something is going on with Snope and with Ocean State Tactical. Now you might say to me, well, they're still drafting their opinions, their dissents. They're still going to deny cert of those cases, Mark, but someone is writing a very long dissent from the denial of cert. That's certainly the most likely scenario one could say. On a bar exam, that would probably be your best answer. But how realistic is that? I'll tell you why I'm not sure that's realistic. Clarence Thomas, for example, and Justice Alito, and Justice Kavanaugh, and Justice Gorsuch have already written over the years dissents from Second Amendment cases that were denied cert. For example, Justice Thomas and Justice Alito wrote a very powerful dissent in that Seventh Circuit case of Highland Park, explaining why the Supreme Court should take an arms ban case. That was years ago. That was before Justice Barrett was on the court, and it was before even Justice Kavanaugh was in the court. I'm not even sure Justice Gorsuch was on the court then. It's been so long ago. The point being is this. If the Supreme Court had already decided to deny cert in Ocean State Tactical and or in Snope, okay, and all they were waiting on to issue that denial of cert in an order form was a dissent from one or more of these justices, those dissents have already been written. They were written years ago, and they've been deployed years ago. It would take almost nothing for these justices who would have dissented in some hypothetical world where cert was denied. It would take nothing for these justices to tweak an old dissent, tweak an old opinion involving the Second Amendment, and hit Control-P and print it. It would be almost nothing to do this. It would take them no time to do this. And yet here we are, 14 or 15 relists where these cases have been considered robustly by the U.S. Supreme Court since the end of last year at the start of January. And again, it's not like this is all going in order because they're denying cert for cases that are older than Snope and Ocean State Tactical. They've been denying cert in cases that are younger than Ocean State Tactical and younger than Snope. And they've been issuing dissenting opinions from those denials, both older cases and younger cases than Snope and Ocean State Tactical. And these cases, Snope and Ocean State Tactical, have been relisted so many times at this point that they're starting to fall into what I call the Dobbs category of cases, where something special, something different, something unique is likely happening with these cases beyond the routine. The routine would be a denial of cert and or a denial of cert with a dissenting opinion saying we should have taken this case. But that doesn't appear to be happening. So I think that's, frankly, positive news. So anyway, folks, I don't want to belabor this point because everyone talks about Snope and Ocean State Tactical all the time in social media and on YouTube. But I do want you to at least hear it from me as to how I'm seeing this. I still remain semi-optimistic something good will come out of this. But obviously, if you're a betting person, you would still be betting that bad news would occur, meaning a denial of cert with a dissenting opinion. But again, the evidence is mounting a little bit that something else is brewing. What I think may be going on is there is an internal negotiation within the U.S. Supreme Court about how to handle these cases, because probably the justices are talking amongst themselves to say, we cannot allow these lower courts to continue to thumb their nose at our Second Amendment rights and our Second Amendment jurisprudence under Bruin and Heller. What are we going to do about this? And there may be a discussion of which case they want to take next term. Do they want to take Wolford dealing with the so-called default rule involving concealed carry? Do they want to deal with that vampire rule? That's a possibility. Do they want to deal, which is kind of a sensitive place case, right, in a sense? Do they want to deal with Snoper Ocean State Tactical, which is a ban case? Do they want to take on a young adult case, for example, if there's a cert sought in the Reese case? Or do they want to take the young adult case, Bondi, out of the 11th Circuit? So again, the Supreme Court may be asking themselves, which Second Amendment cases do we want to take next term? Which do we think makes the most sense? So they may be like at a buffet looking at these various Second Amendment options. Right now, again, off the top of my head, is you got the young adult cases, Bondi and Reese. I don't know if the cert's been sought on Reese yet, but I'm sure it will be at some point. But you got the young adult cases, you got the sensitive places cases of Wolford, you got the Snope AR-15 ban case, and you got the magazine cases of Duncan / Ocean State Tactical. I'm not sure Duncan has sought cert yet, but I assume at some point they will out of the 9th Circuit. So with that said, they may just be looking at this saying, well, I don't know, which one do we want to take? Do we want to take one? Do we want to take more? How do we want to handle this? And I could see a turn of negotiation being going on right now. And also keep in mind, and I'm not making excuses for the Supreme Court because very few people have said the Supreme Court should do more work than I have, but realistically I think the Supreme Court is overwhelmed with all these emergency appeals on behalf of the United States government from this nonsensical lawfare that's going on in these lower courts trying to tank the Trump administration's agenda left, right, and center. And there's no doubt, in my opinion, that the U.S. Supreme Court is overwhelmed and their clerks are overwhelmed doing their normal workload as well as dealing with these emergency motions and petitions that are coming up like on a daily basis. And I suspect that that's probably distracting and delaying some of these big ticket item decisions about cases to take next year, which could include cases touching fingers with the right to keep and bear arms. So anyway, again, I'm just trying to talk to you about the process, about how I think the court may be thinking about some of these issues. I'm not saying you should be happy about it. I'm not saying I should be happy about it. But you don't turn into this channel for rainbows and unicorns. You turn into this channel to get you some hard, solid information. And sometimes the most solid information is not that solid. It requires some speculation. But it's the nature of the beast when you're dealing with appellate practice before the United States Supreme Court, where you're trying to predict how you're going to get 9 justices to line up on a particular issue in a particular case at a particular time. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at 4Box of Iron. Don't forget to subscribe both to YouTube and to Rumble. And I look forward to talking to all of you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.